Yes.
Well, I'm going to correct my shorthand before lunch, for which apologies, and take you to the Technic case, which is in the Authorities bundle at tab 4, volume 1, tab 4. Yes. And there's a passage at the beginning of Lord Justice Jacob's judgment from paragraph 6 on to 15, where he deals with the so-called man skilled in the art in patent law, and he explains they have various characteristics. There's a disagreement with him and Lord Justice Hill about whether they should be called a nerd or not. That doesn't matter for today. And having introduced the concept, perhaps I could direct your lordships to paragraph 12, where he describes the notional skilled person as an artifice, and then he goes on to make observations about whether or not the experts in a case should be, or should approximate to that person in paragraph 12. And he goes on to explain that it's admissible for the expert to give a view on the ultimate question of obviousness. And then he says, although admissible, it's still a matter for the court. And he explains that in paragraph 15. That's precisely why it doesn't matter that the expert doesn't embody the skilled person. What matters are the reasons for his or her opinion.
But I think it's worth teasing out what I think is your submission about this authority, and if I'm misstating it, then you'll correct me. But I think it's worth making it explicit rather than gliding over it, which is that when one looks at the last sentence in paragraph 15, that is a reference back to what he had discussed in 11 and 12. And one needs to be careful about the focus of those paragraphs, because the focus of those paragraphs one sees from the second sentence of paragraph 11, which is the question of what one might call the degree of inventiveness of the witness in question. One has got to be careful to distinguish between inventiveness and the extent to which they are relevantly qualified in the first place.
Of course, but it's not just inventiveness, it's the argument, oh, my expert's more like the skilled person than your expert. So you should...
Well, to that extent, it's against you.
Well, inventiveness is part of it, but this isn't against me on... This is saying that's not... The argument is you shouldn't exclude someone's opinions just because they don't embody the skilled person. And after all, no one can embody the notional skilled person because it is an artifice. We say what the judge has done here, he sought to exclude the views of Dr. Enright, even though in fact on the judge's findings he did embody someone who was working in the...
Well, I appreciate you say this, it's a different point in this case anyway.
Yes. So I hope that's helpful to get...
Thank you. Yes.
So, where does this all take us? We say that if we're right about the skilled person, the court should have assessed obviousness through the eyes of the skilled person as defined by, and indeed with the characteristics of Dr. Enright. As indeed the judge found correctly as a matter of law in 104 of his judgment, if it is obvious to one type of skilled team within the field, then it is obvious. And of course we say that although there were differences in characteristics between Dr. Enright and Professor Rosnecker, if it was obvious to Dr. Enright's skilled person, then the judge should have gone and found it obvious, even if it might not have been obvious to Professor Rosnecker's. And so to assist with that submission, can I show you the way Dr. Enright put it? There's only a brief passage I need to show you in his written evidence. And so you can see the way that the arguments develop. So this is in the supplementary bundle at tab 9. And it's 225 in the physical version. I'm looking for paragraph 7.8.2 of Dr. Enright's first report. And so what Dr. Enright is doing, so it's tab 9, Lord, and page 225 of the. So what Dr. Enright doing, he's summarising, he's gone through the disclosure of UPenn, and he then summarises what the skilled person would think about it in 7.82 onwards. And in 7.83, perhaps I could ask your lordships to read to yourselves 7.83 to 7.85. So if I can summarise those paragraphs, he recognises what he's looking for as a practical utility and applicable to different applications, and pseudouridine would be attractive in that way, 7.83. And as I should say, as a side issue, it was never disputed that one of the things the skilled person would want to do with UPenn is take on pseudouridine, but we also say it was obvious to take on N1-methyl pseudouridine as well. So that's 7.83. 7.84, you wouldn't assume that the results seen with pseudouridine would necessarily be the best, and then the obvious thing to do would be to look at the things that are closest to pseudouridine as being alternatives, and he goes on to identify those in the table, and he confirms that those are the same as those that are identified in paragraph 56, subject to the comments on M5D. And then in 7.86, he says, my approach to what the skilled person would do with these is the same as he's set out previously in relation to Carico 2008. And we'll go to that in a moment. But if I can just show you 7.87 to just show you what his approach in general was. He says M5D would be, because it wasn't a pseudouridine, it would be further down the list. But his view is he'd still go on ahead and test it. And that's relevant to the hindsight argument, which we'll come to in a moment. So if you go back, please, to 6.50, which is on page 221. And again, it's only a short passage. And this is, so he's done the same exercise with Carico 2008, and he's gone and identified from the database those molecules most like pseudouridine, which are the same as those in paragraph 56, except for M5D. And then, if you could, I could ask your lordships to read 6.50 and 6.51. And then it's right in 6.52 and 6.53, he goes on to rank the molecules, but that doesn't matter, we don't need to get into that detail, because his evidence is that he would have tested them all, because he couldn't be sure about his rankings. And so 6.54 and 6.55, he says he'd go ahead and replicate them. 6.55, this would involve the following routine steps. And of course, step A is enough to get you into the claim just by making the molecule. So if I can just return to 7.84 on page 226, and deal with the question of motivation and expectation of success. So this is where Dr. Enright expressed his view, and expectation of success we've seen at 6.50 and 6.51, where he says he'd be more optimistic about some and less optimistic about others. And the point is that this is an empirical field, and that all of these experiments necessarily have an unpredictable outcome. So all that Dr. Enright could do was express more or less optimism about the results. He was consistent in his view that because it was unpredictable, the skilled person would want to test all 5 because they couldn't tell in advance which ones would work, which ones wouldn't, which ones would be better, which ones would be worse. And we say that on the case law, it's clear that it's still possible for something to be obvious without an expectation of success, particularly in an empirical field. And our submission is that expectation of success is really just a subset of motivation. The real question is it obvious to do anything from the prior art, or would you go and do something else? And here, Dr. Enright has expressed why it would be obvious to go ahead and do something with the prior art. 7.84, he explains that. And so there is a motivation to go forward. You might get an alternative, and as he explains, even negative results would be useful in understanding the mechanism. And because this claim is just to a molecule, and all you need to do is follow the directions to make it to fall within the claim, we say that it is legitimate in this case, where there was nevertheless a motivation to consider it could still be obvious even though the results weren't predictable. And that's a mistake that the judge made in 416 of the judgment, where he seemed to think that predictability was a key. So that's the expectation of success point. Finally, we come to hindsight. And this arises in 2 ways. Firstly, the judge finds that it was hindsight for Dr. Enright to focus on paragraph 56 of UPenn. I've already dealt with that as a matter of construction. It's necessary to read paragraph 56 to understand claim 1, the only independent claim to mRNA, which is such a key part of the teaching. So we say it's not hindsight at all. So that's the first point. The other area where hindsight arises is in relation to a specific piece of written evidence of Dr. Enright about the relationship between N1-methylpseudouridine and M5D, which is the non-pseudouridine listed in paragraph 56. And although the judge made a finding about hindsight in relation to his observations about that one point, we say there was no basis for the judge to extend his finding to cover Dr. Enright's views on obviousness generally. And as you can see from what I've shown you, Dr. Enright did not use hindsight in his focus on what he says the skilled person would do, because he said you would test all of the molecules and you would not have a preconceived idea that N1-methylpseudouridine would be best. You would need to test them all, and he was consistent in that throughout. And we say that is the antithesis of hindsight, contrary to the judge's findings on obviousness. So can I take the way the judge deals with this in the judgment, and it's paragraph 53 of the judgment. And just by way of introduction, in paragraph 54, the judge refers to the approach of sequential unmasking. And this is a practice that's developed in patent court cases, where the key is to try and get evidence about what the skilled person would do without knowing of the invention when they're giving their evidence, is to show the expert the documents in order and to record their views about the prior art before they understand what the target is, in an attempt to avoid hindsight creeping. And of course, it's recognised that by the time they have to sign their report, they will have known everything, but the idea is to try and prepare their evidence on the basis that they are showing things sequentially. And so the judge records in 53 that Dr. Enright explained that he was shown the documents in order, and he records that it followed the desirable sequential unmasking approach, and he also records rightly that Dr. Enright was not challenged about this when he gave his evidence generally. And so it therefore follows that Dr. Enright gave his views on the prior art, which you have seen, before he knew what the solution suggested in the patent was, or indeed the molecule, the nucleotide used by Pfizer BioNTech, because he's explained in 53 that he didn't know that when he was preparing his reports. Therefore, on our submission, hindsight was properly excluded from the preparation of Dr. Enright's evidence in the way that the sequential unmasking approach recommends. Nevertheless, the judge goes on in 55 to say not all the main elements or details of Dr. Enright's report were arrived at before he knew about N1-methyl pseudouridine. The problem with that is that's inconsistent with the findings he's made above in 53 and 54, that his approach to the prior art and his approach to obviousness was prepared in the desirable way, and therefore his evidence and his recorded approach to the prior art must have been consistent with what he told those instructing him before he knew what the answer was. And of course, there was no suggestion made by Moderna during the case that the views he expressed in his report about the prior art had been changed once he had seen the patent. So in our submission, Dr. Enright's approach on paragraph 56 must have been completely without hindsight, because he didn't know what was in the patent when he read it and when he expressed his views. And if my learned friends wish to suggest that his report had been materially changed between the expression of his views before he knew what the answer was and signing it, they would have needed to have challenged that, but they did not. They did not suggest...
So I'm confused here, and it's not your fault, but we've got two paragraph 56s in play, and therefore I need to be clear what you're talking about.
I'm sorry.
We've got paragraph 56 of UPenn, and we've got paragraph 56 of the judgment.
Yes, yes.
So can you replay that submission, making it clear what you're talking about?
Yes. So what I'm saying is that in relation to his evidence generally and the sequential unmasking, there was no challenge to the fact that the views he expressed in his expert report about what the skilled person would do with the prior art were the same as the views he gave when he read the prior art before he knew what the answer was in the patent, and indeed before he knew what Pfizer BioNTech were using in their vaccine. And that is the thrust of paragraphs 53 and 54. And if my learned friends had wished to suggest that hindsight had infected Dr. Enright's evidence to such a degree that the views he expressed about the prior art were not, in his report, were not in fact what he said when he first read it, they needed to challenge that, and they did not. So we say it wasn't open to the judge in the absence of such a challenge to say that Dr. Enright's evidence had been infected generally. It is right that the judge then goes on to make a finding in relation to hindsight and the disclosure of paragraph 56 of UPenn, and that confusingly begins in paragraph 56 of the judgment. And the point that is made there, he first of all records the point in 57, and the point was that M5D, as we've discussed, is not a true pseudouridine, and what Dr. Enright said in his report is quoted at 56, second sentence. The skilled person would note that while M5D is not literally a pseudouridine like the others in the group, it does share structural similarities with the others, in particular N1-methyl pseudouridine, which would explain its inclusion. And the judge then goes on to record, it is not in dispute that M5D is in fact particularly similar to N1-methyl pseudouridine. So the debate then came as to whether or not, because Dr. Enright had referred to M5D as being similar to N1-methyl pseudouridine, that indicated some element of hindsight because he was particularly focused on N1-methyl pseudouridine, or whether he was merely saying what was true, which is that of the molecules in paragraph 56, M5D is the most similar to M1-methyl pseudouridine, which is a real pseudouridine. And that, in our submission, is all that Dr. Enright was saying, and he was right to do so, as the first sentence of paragraph 58 records. Nevertheless, the judge goes on to suggest that Dr. Enright was making more in this sentence than the explanation I've just given to you. He doesn't record in 58 that when it was put fairly to Dr. Enright that on this narrow point he was using hindsight to when he referred to M1-methyl pseudouridine. Dr. Enright rejected that, but nevertheless the judge goes on to make findings adverse to Dr. Enright. And what he goes on to explain is that in 58, 59, 60, is that if you went to the modification database, you would see that there were other nucleotides out there which looked more like N1-methyl pseudouridine than M5D. And that, in the end, that wasn't in dispute. But Dr. Enright's explanation as to why he hadn't made that point in his evidence was that that was going down a rabbit hole, as the judge records in paragraph 59, and that the skilled person would just look at the molecules and see the similarity and stop, and wouldn't go and look for other molecules and see if there were other molecules that were even more similar to M5D than N1-methyl pseudouridine. And so when the judge says in paragraph 60 that Dr. Enright could not have made the point about the similarity between N1-methyl pseudouridine and M5D, it's right that he could have left it out of his report altogether, but that was his view, and he maintained it, and he maintained that the skilled person would look at the level of the similarities of the molecules in paragraph 56 of UPenn and wouldn't go further and go back to the database and do all the further comparisons. We reject the suggestion in the third sentence of 60 that Dr. Enright plainly went further than just stating a fact because he was seeking to explain what the skilled person would think. We say he was just commenting on the structural similarity between M5D and N1-methyl pseudouridine, which everybody had agreed. He then goes on to say there was more to be said, but that's the rabbit hole which Dr. Enright didn't think the skilled person would go down. And then the judge concludes that this indicates that Dr. Enright had a particular focus on N1-methyl pseudouridine, and that infected all of his evidence. But as he later records, and as I've shown you, Dr. Enright actually said he would test all of the molecules in paragraph 56 of UPenn. So he didn't have a particular focus on N1-methyl pseudouridine. And it was never part of his obviousness analysis that you would focus in and that would be the only one you'd be interested in. And so even if there was some element of hindsight in this very narrow point about the comparison with M5D, that just doesn't transfer to Dr. Enright's evidence as a whole, because he said you test them all. It was unpredictable which would work and which wouldn't. And he stuck to that view both in his written and in his oral evidence. So we say it was quite wrong and unfair for the judge to rely on this purported example as infecting all of Dr. Enright's evidence when that was never put to him, and it would need to have been if it was going to be made. And so when the judge in 63.1 expands the M5D point to a conclusion that hindsight was appreciable, we say he wasn't entitled to make that finding when it was never suggested to him and it was unfair on the basis of the description I've given to you. And it was also contrary to his acceptance that the evidence was given following the sequential unmasking approach. Because what the judge is really saying here is that you can't accept any of the evidence on the prior art of Dr. Enright because he considers that what was written in his report must have been materially different to what he actually said when he read the prior art.
What is the test that we apply to this argument?
I understand that the difference. This is an assessment by the judge, but it's an assessment by the judge that went further than Moderna submitted at trial, and Moderna never challenged Dr. Enright's views on the prior art per se as being given with hindsight. They did challenge this point, I accept that, but they didn't go further and say that that means that all of Dr. Enright's views on obviousness were given with hindsight. And moreover, it ignores the fact that there's no room for hindsight in Dr. Enright's approach because he said you would test all of them. And if you're with me on the impact of Claim 1 of the prior art and paragraph 56, then there's no room for hindsight because the skilled person looks at all of the molecules in paragraph 56 and would make and test them all. And therefore, the judge is not only unfair, we say, but also wrong to say that hindsight can creep in at all to the analysis when it's plain that Dr. Enright just said you test them all, and of course all you need to do is test them all to make them. You don't have to have a pre-expectation of which one is going to be better than the other. So in 62, this is where he comes back to Dr. Enright's focus on paragraph 56. That's all bound up in the points on construction, which I've dealt with. And therefore we say, if that's the case, the judge's conclusions in paragraph 66... That
Sorry, what does he mean when he says relative to 291?
So 291 is where, is example 31, where you are told to go and test molecules. And the judge says that it's wrong. You can't go back and say, oh well, I'm told to test molecules in example 31, and then I go and test the molecules which fall within claim 1, which are as defined by paragraph 56. And that's
sorry. Is there some antecedent in the analysis that the judge is referring back to here? Because at the moment I'm not spotting it. It's the comparison with 291 seems to pop out at paragraph 62 out of the blue.
Yes, I agree. We're not aware. And in fact, when we go on later, you'll see that the judge does in fact agree that 291 gives you a promise and some impetus to test. So it's quite strange that, having made that finding, he is apparently criticising Dr. Enright in this paragraph for having some impetus to test from the UPenn document. So if I can go on to the judgment and show you, try and pull these points together and show you where we say the judge went wrong with this combination of wrong skilled team, wrong approach to the prior art, and hindsight and expectation. So it begins at 358, and he sets out the two contentions of the parties. And there's only one correction I need to make here. It was never our case, as I've explained, that it was not obvious for some of the skilled team to take pseudo-uridine forward. So the judge's reference to instead in line 4 doesn't correctly reflect. That should say would as well be encouraged to investigate. And as I've explained, it's right that Professor Rosenecker was particularly focused on therapy and had waited for many years to try and advance the treatment of cystic fibrosis. And so his evidence was that he would be very keen to take pseudo-uridine forward for that very purpose. Even though, in fact, his team investigated other nucleotide modifications at the time, after the publication of the Carrico 2005 paper. But that, as we've explained, completely ignores what other skilled teams would do And crucially, as I put to Professor Rosnecker on a number of occasions, he was unable to explain why the skilled person not in his position, who, like him, interested only in immediate protein therapy, might not want to try the other pseudouridines when they were easy to make and test. So 360 accurately summarises our case before the judge, noting the finding that if the skilled person made the the N-methyl pseudouridine modified mRNA of claim 1, he finds the most obvious thing to do would be to make the 100% modification. That's little 5, which he says he accepts in 363.
Sorry, you said, I think a little while ago, I mean, the evidence of Professor Enright was that you would test all.
In paragraph 56, yes.
And where's that reflected in the judge's summary of your case?
Well, that's we say he ignored that. This is he didn't, because he wouldn't have found that hindsight could have infected the view if he had had that in mind. He does come on to deal with some of the points in a bit more detail later, but he doesn't really grapple with the fact that Professor Enright was consistent that you would test them all. He deals with it on the basis that if you have no expectation that any of them are going to work, that's not an obvious thing to do. But Professor Enright answered that in his evidence, we say, for good reason. Yes. So I think maybe in little 3, the ones of interest would be the pseudouridine-like ones. So that encompasses all of those in paragraph 56. But he doesn't go on and say differentiate between N1 methyl pseudouridine and the others. So in 363, the judge explains that points 1, 2 and 3 above are the key. He first comments on step 1, that is promising results in UPenn for pseudouridine, and that's at 365 onwards. And it's right that the evidence was that the skilled person would not know why pseudouridine worked. That's 366. But we say that doesn't lead on to the conclusion that they would only take pseudouridine forward if it was also obvious to try the variants of pseudouridine to find alternatives. And indeed, the judge went on to say in 369 that this point doesn't really matter. So his real focus was little point 2 and little point 3 in his list in paragraph 360. And he deals with this in 371 onwards, that is to say, the decision to explore other molecules and that the pseudouridine-like ones would be the most interesting. And again, this is partly a variant of the construction point. We've already been over to some extent on novelty, because of course, UPenn directs you to the pseudouridine-like molecules in paragraph 56 by virtue of the definition, and the skilled person would recognise that those were the pseudouridine-like molecules, and they would understand the reason for wanting to test those was because pseudouridine itself had been successful, and therefore you want to see if you can get a better or alternative or as good as effect from something that is only a little way away from pseudouridine itself. So we agree, and the skilled person would agree, that pseudouridine itself is good, but that is precisely why the skilled team would also be interested in looking at pseudouridine-like molecules. And so the judge summarises his position in 379, and these are really all mirrors of the construction points that we've already discussed. So the first point, he says it's a definition only, not a technical teaching, but we've already explained why, because this is the teaching that goes with claim 1, and claim 1 is the only mRNA, only standalone claim for mRNA, then it would be seen as a key part of the teaching of the document. Little 2, he refers to the presence of M5D, and that might be confusing. but the judge himself recorded, based on evidence from Dr. from Dr. Rosnecker, that the reader would think that M5D had been consciously included. There would be a reason why Carricker and Weissman had put M5D in the list, and he makes that finding in paragraph 404. And so the fact that M5D is there wouldn't put the skilled person off, because the skilled person would think that it had been put there deliberately by authors of such renown. Point 3 is again the open-ended point, and we say that's a distraction, and it would not put people off the list of pseudouridines that are there, particularly when, in fact, if they did go and look in the database, they would find that there were no other natural pseudouridines. Little 4, he refers to the other lists in the document, but again we say that this, because this is linked to claim 1 and the only standalone claim to mRNA, the skilled person, and it comes first in the document, the skilled person would give it more weight. And then finally, in 5, this is where he refers to the positive teaching elsewhere in the document, in 291. So he is accepting there that there is a positive teaching in example 31 to look for other better nucleosides, and we continue to rely on that in relation to the novelty case. But as far as obviousness is concerned, it doesn't matter that the teaching is maybe in another part of the document. It is still a positive teaching to go further, and that is the skilled person is entitled to give weight to. So that's why we say the judge is wrong in relation to each of these points. In 380, he says it's wrong to give primacy to paragraph 56. Again, our response to that is no, because it's linked to claim 1. And it's not just because it comes first in the document. It's linked to claim 1. It's also because pseudouridine itself is so good, and so you would want to look at other molecules that are most like pseudouridine. 381, he refers to the fact that you don't know what the result will be, and you don't know whether it's going to be as good as pseudouridine. But as we pointed out, this is an empirical field, and you could never know. And you don't need to be sure. You just need to think it's worth testing to get inside the claim. And for all the reasons we've given, we say that Dr. Enright's evidence on that was that it was worth testing, and that represented what the skilled person would think. And 382 is a really further extension of that. We accept that you wouldn't know why pseudouridine itself worked, but that's a further reason to test, because by testing molecules that are like it, you come to an understanding of why it is pseudouridine works and why it is that maybe some of the other molecules work as well. And indeed, the evidence on this was Dr. Enright said you would test, Professor Rosnecker said you could test. If the skilled person was the skilled person within Dr. Enright's realm, then the would test is enough to make a finding of obviousness. Finally, in 384, the judge deals with the alleged inconsistency. And this again is unfair. This is where the judge says that it's wrong for Dr. Enright to have first prioritised them, but then said he'd test them all. We say it's not inconsistent at all. It's right that the skilled person would theorise he might expect ones without Watson-Crick interference to work better, but he couldn't be certain, and so he would go ahead and test all 5 anyway. As we said, there's nothing inconsistent in that, and it actually shows an absence of hindsight, contrary to the judge's earlier findings. Then we come to Charette and Gray, and I'm obviously not seeking to go behind the factual findings on this, but even on the judge's approach, these findings were only a pointer against obviousness. So I'll deal with this purely as a matter of law.
All right, but before we get to the matter of law, you need to explain to us what the relevance of this article is.
Yes.
At all.
So this arose out of the Dr. Enright's theory about whether or not N1-methyl pseudouridine would work. And there was a review paper called Charette and Gray, which was referred to in the database under the heading for pseudouridine. And that suggested that hydrogen bonding was necessary for stability. And if you put the methyl group on N1 methyl pseudouridine, that might remove a hydrogen bond, and therefore that might cause you to think that it might be less effective than a molecule with the hydrogen bond, such as pseudouridine itself. And there was another...
Sorry, you're getting into the detail.
I'm sorry.
At this stage is not the point of my question.
Sorry, I apologise.
My point of the question is, why are we looking at it at all?
Right.
So if I've understood correctly, the hypothesis is that the skilled person reads UPenn. They would already know about the database, but in the event it's referred to it. And so from UPenn, they go to the database, and then, as I understand it, they see in the database a reference to Charette and Gray.
Yes.
And they go from that to Charette and Gray itself.
Yes.
Now, my question at this stage is a simple one. Is it in dispute that that's what the skilled person would do? Because at the moment, I haven't understood that to be in dispute, but I want to be clear.
I'm not challenging the judge's findings, that's what the skilled person would do.
Right, okay.
And I'm not challenging the judge's conclusions in relation to Charette and Gray, which is that it is a pointer that might make you think that N1 methyl pseudouridine might not work as well as pseudouridine. But the point I'm wanting to emphasise is that this doesn't really matter in the scheme of Dr. Enright's approach to obviousness, because it was never suggested to Dr. Enright that the contents of Charette and Gray would put the skilled person off completely from testing N1 methyl pseudouridine. As the judge characterised it in 415, it was only a pointer, and it might push pseudouridine if you're in your theorised approach before you start the experiment down from position 2 to position 3, but it was never suggested that you wouldn't still test N1 methyl pseudouridine as part of the 5 that are listed. Given that there's no expectation, you can't have an expectation either way, the impact of Charette and Gray is limited. It is still worth trying for the reasons that Dr. Enright pointed out, and we say the judge lost sight of this in placing, or if he placed as much work as if he placed so much weight on it that there was any suggestion that he wouldn't even test N1 methyl pseudouridine. That's not in fact part of his finding. It's only a pointer. So whilst I accept the findings of the judge on Charette and Gray, it's not a trump card that my learned friend can say, ah, well, I get home whatever happened just because of the findings on Charette and Gray. So, my lords, perhaps I can skip on to 409, which is where the judge deals with the fact, he relies on the fact that there is no positive consideration of expectation of success. And it's true, that was Dr. Enright's evidence, and it's correct that he, as you've seen, as he explains, the skilled person would want to test because these molecules are pseudouridine-like, but because this is an empirical field, they could not tell in advance whether or not one was going to be better or worse. And we say this is precisely the type of case where you don't need to have an expectation of success because the skilled person would go ahead anyway. This was routine work. It was scientifically meritorious.
I'll just press you a little bit on that because I'm not quite sure I'm understanding that. And the question is always, is there a sufficient expectation of success to warrant doing the test?
Yes.
I assume you wouldn't argue that if you positively expect it to fail, it can still be obvious.
No, that I don't need to go that far. The judge
So therefore, expectation of success has to come into the analysis to some degree.
Yes. You have to think there's going to be something useful.
Something that has a sufficient possibility, to use a different word, of success.
Yes.
To make it worth testing.
Yes, but in the circumstances of this case, that can also include getting a negative result for a particular nucleotide. Because if you put M5D through and found it didn't work, that might tell you that something that's further away from pseudouridine is not what you want, for instance. And Dr. Enright explained that would be useful still. So a negative result would still be useful.
Yeah, but that's a negative result when you do the test.
When you do the test, yes. There's still enough motivation for you to do the test. And that's the point that we emphasise. And so we say it wasn't in dispute this was routine work. It was scientifically meritorious for someone like Dr. Enright, as the judge himself found in 416, and you would do it to investigate alternatives of pseudouridine and to work out why pseudouridine worked, as Dr. Enright explained. In 411 and 413, the judge makes findings about Professor Rosennecker's paragraph 40, which do support, as the judge found, the notion that the molecules in paragraph 56 would be the ones of most interest to the skilled person, and we continue to rely on that in support of our case. We've looked at 415 and 416 already, and for the reasons I've given, we say the judge had the wrong skilled person, wrongly focused on therapeutic outcomes only, had a wrong focus on expectation of success when the test is just, is it obvious to make the molecule, and wrongly took into account hindsight because Dr. Enright's evidence was that all molecules would be tested. The judge goes on to discuss expectation of success further in 417 and 418, and we say although he accepts that the doctrine may not be relevant to some cases, it's plainly not limited to the factual scenarios he there refers to. In 418, he accepts that the experiments would be routine. Experiment formats proposed by Pfizer Ltd would be routine, but he goes on to say, but it's unclear what variants to test. We say that's not right because paragraph 56 lists the 5 variants expressly, and that also coincides with Professor Rosennecker's paragraph 40, where he agreed that you would come up with the 5 variants as being the most like pseudouridine. So his mistake on paragraph 56 of UPenn goes to the heart of his obviousness finding too, because for some reason, right at the end of his obviousness finding, he's still questioning what variants to test when we say it's absolutely clear from paragraph 56 of UPenn those are the pseudouridine-like molecules linked to claim 1, and that's what the skilled person would be interested in. We were not saying, as the judge seems to record in 418, that the unpredictability of the results doesn't matter at all. What we were saying is that the unpredictability of the results would not prevent the skilled person going ahead in the circumstances of this case. 419, the judge accepts that there were other options and that it would be wrong to say there's only one obvious thing to do. And we say that Dr. Enright had set out what those options were. 420, the judge describes it as a formidable research project, but that's just not right, given the findings in 418 that it would be routine, and that there is only a limited list of molecules in paragraph 56 to test. It's not a scattergun approach, as the judge seems to characterise it. Again, we say he has wrongly construed prior art, wrongly understood what the skilled person would make of it, and that has fed all the way through into these findings on inventive step. And of course we say essentially this is what Moderna did. They did what UPenn suggests, which is test for other molecules, and we ask rhetorically, how can that possibly involve the inventive step when that is set out, and the judge accepted it was set out as a promising thing to do in the prior art. So, my lord, standing back, we say if we're right about the skilled person, then the judge would have been bound to make a finding of obviousness. It's clear that the judge's reasoning followed squarely from his exclusion of someone with the characteristics of Dr. Enright's skilled person, and this also negates the consideration of expectation of success and makes the hindsight point irrelevant for the reasons I've been through. And so if the skilled person is defined as including the sort of person that Dr. Enright proposed, the judge should and would have determined that Claim 3 did not involve an inventive step over the pen. So, my lords, unless I can assist you any further, that was what I was planning to say on our appeal.
No, thank you very much.
May it please your lordships. With
Yes.
your lordships' consent, I'm going to address you on novelty, and my learned junior, Dr. Barrow, will be dealing with the obviousness appeal.
Thank you.
That's acceptable. What I'd like to do is I propose to start with the law in relation to novelty, and then address your lordships on routes 3 and 1 in that order. As far as the law is concerned, there's no dispute in the present case that the judge correctly identified the disclosure test for novelty. I'm quoting from paragraph 13 of my learned friend's skeleton. Subject matter must be directly and unambiguously derivable from the prior art. Alternatively, the prior art must contain clear and unmistakable directions to do what the patentee claims to have invented. Now, the clear and unmistakable directions, that language, comes from the judgment of Lord Justice Sachs in General Tyre, a case which my Lord Justice Arnold will be very familiar. I venture to suggest that my Lord Justice Snowden and Moylan may be less familiar with General Tyre. And so can I just show you the relevant passages from that? If your lordships...
Well, by all means do that, but of course, what's binding upon us is the House of Lords in Synthon.
Absolutely.
Which is both later and of superior authority.
It is, and that's why I was going to take you to Synthon rather than General Tyre.
Oh, okay.
So Synthon is in JA1 tab 5. And I'm going to use the bundle pagination, if I may. I hope it aligns with your lordships. Let's see how we go. I'm going to pick it up at...
Not quite electronically, but I've got it now.
All right. Page 230 of the bundle, internal 693. Paragraph 20, Lord Hoffman says, the concept of what I've called disclosure has been explained in 2 judgments on questionable authority. First is Lord Westbury in Hill and Evans. And then 21, the second authoritative passage of the judgment of the Court of Appeal, General Tyre and Firestone. And where I was going to pick it up is paragraph F, the paragraph that starts where the prior inventor's publication patentee's claim would be respectively construed by the court in the light of all properly admissible evidence. Rather than just reading it out, could I ask you lordships to read that paragraph first, F down to J?
Yes.
And then I was going to ask you lordships to focus then on the next paragraph. One gets the context from the previous paragraph. So starting at the bottom of the page, if on the other hand the prior publication contains a direction which is capable of being carried out in a manner which would infringe the patentee's claim, but would be at least as likely to be carried out in a way which would not do so, patentee's claim will not have been anticipated, although it may fail on the ground of obviousness. To anticipate the patentee's claim, the prior publication must contain clear and unmistakable directions to do what the patentee claims to have invented. A signpost, however clear upon the road to the patentee's invention, will not suffice. The prior inventor must be clearly shown to have planted his flag at the precise destination for the patentee. And that planting of the flag is a readily comprehensible formulation of what the law is requiring. Now, at 22, Lord Hoffman says, if I may summarise the effect of these two well-known statements, the matter relied upon as prior art must disclose subject matter which, if performed, would necessarily result in an infringement of the patent. And he says that maybe because the prior art discloses the same invention. In other words, it actually discloses, one can see it on the page if it's a documentary piece of prior art. In that case, there will be no question of the performance of the earlier invention would infringe, and usually it will be apparent to someone who's aware of both the prior art and the patent and so that can do so. Patent infringement doesn't require that one should be aware of what is infringing, and he then quotes from Merrill Dow, and at D, it follows that whether or not it will be apparent to anyone at the time, whenever subject matter described in the prior disclosure is capable of being performed and is such that if performed it must result in the patent being infringed, the disclosure condition is satisfied. Now, whilst we've got Synthon open, could I ask your lordships just to pick up in paragraph 23, having referred again to Merrill Dow, at F is the paragraph reference. There's a sentence that starts, but the infringement must not merely be possible or even likely consequence of performing the invention disclosed by the prior art. It must be necessarily entailed. There's more than one possible consequence. One cannot say that performing the disclosed invention will infringe. The flag has not been planted on the patented invention, although a person performing the invention disclosed by the prior art may carry it there by accident, or if he's aware of the patent invention by design. Indeed, it may be obvious to do so, but the prior disclosure must be construed as it would have been understood by the skilled person at the date of disclosure, and not in light of the subsequent patent. That's important, my lord. It's important that one is undertaking the exercise without hindsight. And Lord Hoffman then quotes for that proposition from the Technical Board of Appeal in Union Carbide. And perhaps if your lordships can just read the quotation from that case that Lord Hoffman identifies.
Yes.
And then at 24, he says, although it's sometimes said there are two forms of anticipatory disclosure, a disclosure of the patented invention itself, and a disclosure of an invention which, if performed, would necessarily infringe the patented invention. See, for example, Laddie J and Inhale. They are both aspects of a single principle, namely that anticipation requires prior disclosure of subject matter which, when performed, must necessarily infringe the patented invention. Disclosure of subject matter. Now, what is the relevant subject matter which, if performed, will necessarily infringe the patented invention is a question which has to be asked on the basis of the particular document, in the light of the particular facts of any particular case. And so when we come on to two routes which are relied upon for the purposes of anticipation on this appeal, the lordships will, in my respectful submission, want to bear in mind that the endorsement by Lord Hoffman of the propositions that we've seen in general type about clear and unmistakable directions to do what the patentee claims to have invented, and likewise we'll need to look carefully at what the relevant subject matter is of the disclosure which is relied upon for the purposes of each route. That's all I wanted to get from Synthon and General Tyre for the moment. Can I then turn to the judgment? And could I pick it up at page 74, paragraph 123, you'll see the judge there referring to the clear and unmistakable standard and both general tire and sin. Now, turning over the page, could I just alert your lordships to a number of principles which the judge sets out as a matter of law, and those are principles which plainly inform his assessment of the novelty routes in due course. So at 126 of the judgment, page 75, he says the gold standard formulation above refers to the whole document and to the common general knowledge. I accept, of course, that the whole document has to be considered, but that doesn't mean that it's a reservoir from any part of which a feature can be taken to combine with a feature from some other part in the absence of a clear teaching to do so. Similarly, the common general knowledge informs, as ever, what the skilled person understands from the document, but it does not make the common general knowledge a reservoir from which features can be freely drawn to be plugged in at will. And he says, I'll return to the role of the common general knowledge in a little more detail in relation to selection from multiple lists, which he does do. So the judge, so far, has got clearly in mind the basic standard. He's got clearly in mind that it's the whole document that needs to be looked at. The document has to be understood with the common general knowledge, but the common general knowledge cannot simply provide a reservoir for the addition of features. He then turns to individualized description and selection from lists. And your lordships will see that the judge then quotes paragraph 23 through to paragraph 33 of Lord Justice Jacob's judgment in Dr. Reddit's. And just picking it up if I can, paragraph 28 of Dr. Reddit's, and my learned friend has shown you this paragraph 28, where the Lord Justice says that there is in principle no difference between listing out a great number of compounds and the use of something like a Markush formula. Now, my learned friend says it may not be necessary to resolve the correctness of that statement, and my lord, we would entirely endorse that proposition. It may not be necessary to resolve it for this reason, at least. If your lordships turn on to paragraph 129 of the judgment, the judge says, amongst other things that he found particularly helpful, this is the last sentence of 129, he says, I also note the Court of Appeal was clear that there is no conceptual difference between a list and the identification of a group such as a Markush formula. The judge accepts that. And there's no appeal against that aspect of the judgment. Now, my learned friends say, well, where has that principle ever been applied? And he went so far as to say no one has found a case where a compound has been found to be submerged because it is in a list that is too long. Now, that principle, albeit expressed obiter in paragraph 28, is one which has been followed in at least one case in this jurisdiction, and that is GSK and Wyeth. And I do want to show you that. It's at JA2 tab 11. And if your lordships please turn to paragraph 68 of the judgment, page 487 of the bundle, you'll see the judge identifying the claims in issue.
Sorry, can you give me the reference again?
Bundle reference, page 487.
Thank you.
And you'll see that the subject matter of claim 1 was a composition comprising one of a number of particular amino acid sequences, 212, 214 and 216, together with at least one poor A protein. That's a particular type of protein. And if your lordships then turn on to page 508, paragraph 156, the judge summarises the anticipation case. And the anticipation case depended upon a patent numbered 885. And you'll see in the little Roman points, the subject matter of the invention relates to vaccines. And then little Roman 2, on page 2 of 885, a list is provided of potential antigens, makes a reference to a series of other documents, including International Patent 280, and the list of antigens from 280 is then written out on page 4 of 885. So the prior art writes out a long list of antigens. And just so it makes sense of what we then come on to see in a moment, little 3, among the preferred options for the antigen to be added is sequence number 2356. And you'll see in a little Roman 4, this is a protein comprising the amino acid sequence having sequence identity greater than 95% of sequence ID number 212. In other words, it was an antigen within the scope of that part of the claim. The judge says at 157, Wyeth submits that anticipation requires a sufficiently individualized disclosure, which is a matter of degree, and the judge accepts that, and he refers to Dr. Reddy's in that paragraph. If your lordships then turn over, I'll try to make it as simple as I can. Paragraph 160 of the judgment. The judge is there recording the various documents which are cross-referenced to in the prior art. And amongst those, you see it's the first one, a protein disclosed in WO99 57280, and then a list of other documents which are cross-referred to on the next page. And then, if you lordships will turn to page 511, the judge says in the case of 280, so this is in the case of one of the documents to which a cross-reference is made, protein is preferably selected from a very long list of 1,510 sequences set out at page 4, lines 9 to page 6. So this includes every numbered amino acid. 165, there's no preference for sequence ID 2536, which is the relevant one. And in 166, the judge says a skilled person will be required to pluck out 2536 from the list of 1,510 proteins from 280, which comprises all of the proteins in that document. The references to 280 and 885 are no more than a reference to the document as a whole and provide no technical information. I'll ask your lordships just to bear that in particular in mind. No reference to technical information. And then I think I can jump straight to 168. In conclusion, I do not consider that there is an individualized disclosure of sequence 2536 in 885. Alternatively, I don't consider there's a clear and unambiguous disclosure of the combination of that sequence with a particular outer membrane protein containing pore A. So there is a judgment in which the prior art discloses as a long list suitable antigens, and the judge finds that that list is too long and provides no technical information, and therefore there is no individualized disclosure of one of its members. So if I go back to the judgment and looking at the quotation from Dr. Reddy's by the judge, so I'm page 76 of the judgment. We've looked at paragraph 28, and then at paragraph 31, Lord Justice Jacobs says it's not necessary here to go into what is sufficient to amount to an individualised description. He says, obviously the question may be partly one of degree, but other considerations may come in too. For instance, the specificity of any indicated purpose for making the compounds. A mere woolly indication of the possible use of the prior class may require less specificity than a precise one. Now, the judge, at page 78, paragraph 129...
Quite a hard sentence to understand, that.
It is quite a hard... It is.
Because he seems to say, if you read it literally, the opposite of what he means.
It does, absolutely. I try to read it, and I have spent quite some time trying to work it out. But I think...
The sentence is the opposite to what it literally says.
Exactly right.
Yeah.
I mean, put it this way, a woolly indication isn't good enough.
Yeah.
Now, the judge in paragraph 129, which we looked at just a moment ago in relation to there being no conceptual difference between the list and identification of a group, says he has found it particularly helpful and relevant to the overall test, the guidance that the question is one of degree, and the pointer in paragraph 31 that the specificity of any indicated purpose can be relevant. So just pausing there, the length of the list, this is all part of the context of the disclosure. Maybe the list is too long. There are other contextual elements, one example of which is the specificity of any indicated purpose. But my submission to your lordships is what Lord Justice Jacob is saying there, and which the judge adopted, and in respect of which there is no appeal, is sound. And when I say that it is not the subject of an appeal, my learned friend's skeleton argument positively endorses this approach. Paragraph 72, page 295, I've got as a bundle reference. We've addressed the law on individualised descriptions above. The question is partly one of degree. The judge was right to find that there is no fixed numerical cut-off for individualisation, and the context of the disclosure will be relevant. Now, lengths and context is going to be relevant, both in relation to route 1 and route 3, which I will, in due course, seek to explain. Can I then turn on to back to page 78?
Well, just a moment. You were suggesting that there was no challenge to what the judge had said in 129, but the cross-reference here is to 131. And there might, I don't know, there might be a difference between context, because of course, as Lord Hoffman famously reminds us, no one ever made an acontextual statement, so context is always relevant, inevitably. But there may be a difference between what is the context in the source document and specificity of purpose, which might be different.
Indeed, I would have, my submission would be, as your Lordship says, context is always relevant. Specificity or purpose is, may be one of the relevant considerations that bears upon an individualised description.
You say that's part of the context.
I say it's part of the context. Now, having, we looked at paragraph 129, the judge says in paragraph 130, these principles have been applied on numerous occasions in the UK and in the EPO. And my learned friend took you to this paragraph, in particular focused on the fact that the judge referred to different numbers of possibilities on different ends of the spectrum, and that Almiral, as far as the judge is concerned, is on the same spectrum. My submission in that respect is what the judges is doing in 130, and indeed one can see it from the surrounding context, 129 and 131, is he's talking about numbers. The judge plainly acknowledges or knows that the disclosure in Hurst was a disclosure of a racemate. So in other words, a disclosure of a class. And in Dr. Reddy's, it was a disclosure of a class, a reference to a Markov formula. And in Almiral, it wasn't a class. It was a list of specific worked examples. The judge, in my respectful submission, is simply saying here, because there's no fixed cut-off and it's a matter of degree, there are cases where different numbers of compounds have fallen to be considered. And as he says in 131, each side before me accepted there's no fixed numerical cut-off. I will proceed on the basis that the overall test is whether there's an individualised disclosure and that the size of the list or the class is one relevant factor. Now, I think I can take the rest of the judge's account of the law relatively quickly because none of it is in dispute. But could I just take your lordships to the extracts from the guidelines of the European Patent Office, which my learned friend handed up. And he took you to section 7, selection inventions. Selection of one or more elements from a single list of specifically disclosed elements does not confer novelty. Could I ask your lordships just to turn over to the next page but one, where you'll see in the middle of the page, just above the first hole punch, multiple selections identified. And the guidelines are crystal clear. If multiple selections are identified, the situation becomes more complex to assess. Depending on the type of the selections, this generally leads to one of the following three scenarios. A, the identified selections involve the selections of individual elements or in selection of subsets of multiple larger sets. This amounts to a selection from two or more lists of a certain length. A list is a description of equal, i.e. non-convergent alternatives. A list is usually considered to have a certain length if it has a length of at least 2 or 3 elements. Whether a list has the required length has to be decided on a case-by-case basis. Absolutely right. Has to be decided on a case-by-case basis. It's a matter of degree. It's a matter of evaluation by the tribunal based on the disclosure of the document and the evidence that he or she has heard. And the guidelines go on to say if a selection from two or more lists of certain length has to be made to arrive at a specific combination of features, then the resulting combination of features not specifically disclosed in the prior art confers novelty, the two-list principle. On the other hand, novelty is not conferred if there is a pointer in the prior art to the specific combination. Similarly, merely reducing the length of the list doesn't generally confer novelty if their length is not reduced below the required length. And for reasons which we've explained in our skeleton, and I will elaborate on, when it came to assess routes 3 and routes 1, the judge rightly undertook an analysis by reference to the selection of the relevant features from two different lists. Now, turning on to the rest of his account of the law, I'm not going to dwell on any of it in particular detail, save for what the judge says in paragraph 138 and 139. And 138 follows from 136, in which the judge explains that the approach is not mechanistic or formalistic in the sense that a choice from two lists does not automatically mean there is not individualized disclosure. Ultimate question is still clear and unambiguous disclosure. And that provides the context for which he says in 138, one way in which the application of the two-list principle might be unduly mechanistic and out of keeping with the underlying gold standard would be if all possible combinations arising from the twin choices were artificially treated as being of equal significance, when the disclosure of the document in question placed more emphasis on some than others. Thus, the EPO case law recognises that there may be implicit or explicit pointers. Various such pointers have been recognised by the EPO, and each side before me referred to the case law. In paragraph 139, my Lords, I would ask you, please, to focus on the three propositions which are contained in 139. Because as we shall see, the three propositions in 139 are propositions on which the judge rightly relied when he came to assess the novelty of routes 3 and routes 1. So the first of those is that there's no conceptual limit on what may be a pointer, but a particularly common one is a statement of preference with a list of the document in question. So that's the first. The second is the judge refers to a number of EPO cases in which it was held that there was added matter in combining a preferred member of one list with a member of another list for which no preference was expressed. That's the second proposition. And the third, the judge says in general too, what the EPO looks for is a pointer to the combination. This cannot be an absolute rule, but it does, but it makes sense. You see, for example, two particular cases. So those are three important principles, not suggested to be wrong on this appeal, but principles which the judge has adopted in his approach, or his account of the law, and as we will see in his assessment of the novelty anticipation attacks. My Lord, actually, I'll just pick up on two further paragraphs, if I may. Three further paragraphs. Next page, page 80, 141, the judge returns to the common general knowledge. And having quoted from Euro-Celtic, judge says at 142, Pfizer BioNTech accepted this, and I agree. This is the difference between using the common general knowledge to assess the skilled person's understanding of what is disclosed and using the common general knowledge as a reservoir of additional disclosure. The former is mandatory and the latter is illegitimate. And then 143, as with the other matters discussed above, just pausing there, in my submission, that is the judge referring not just to selection from multiple lists, but he's also talking about individualized description. Pointers are a facet of the gold standard and not a replacement of it, or a replacement of it. And then lastly, paragraph 146, this is the last paragraph of the judge's account of the law. Finally, at the risk of repetition, the test of clear and unambiguous disclosure is emphatically not an obviousness test. Point is in particular a facet of deciding the question of clear and unambiguous disclosure, not a license for holding something to be disclosed merely because it was an obvious choice. This may be easier to say than to apply, but on novelty, I think it is of some importance. Well, that's the judge's account of the law. Can we then turn to route 3? And could I ask you to turn to page 114 of the judgment?
Page or paragraph?
Paragraph 307. Because at paragraph 307 to 312, the judge is providing some introductory remarks before he then goes on to look at the various routes. And in 312, the judge reminds himself of the target for the anticipation attacks and the particular 3 combined features of Claim 3, a messenger RNA, M1-Psi has to be used as a modified nucleotide, and 100% of the uracils have to be replaced. It's all of those 3 features that have to be brought together. And by underlining the M in mRNA, the judge is emphasising that Claim 3 requires a specific type of RNA, namely messenger RNA, and the significance of that feature can be seen in the agreed common general knowledge. And I'll just show you 2 or 3 paragraphs. Page 89, paragraph 176. Cells produce several types of RNA, as summarised in the table below. And if we just look at some of those RNAs, the first of those is messenger RNA, which codes for proteins. Indeed, it's the only type of RNA that codes for proteins. Can I just draw your attention to some of the other RNAs that are in this table? There's ribosomal RNA, there's transfer RNA, both involved in the process of translation. Small nuclear RNAs, and then 3 down from the small nuclear RNAs we see the microRNAs and the small interfering RNAs. And in 177 there's an explanation of the concept of gene expression, the process by which genetic information contained in a gene, that is to say in DNA, is represented in the form of its corresponding protein. Some genes are not represented in the form of a protein, but are nevertheless expressed. For example, genes that are coding tRNA and ribosomal RNA, which are transcribed but not translated. This process, that is to say the process of gene expression, involves 2 discrete steps: transcription of DNA to RNA and translation of RNA to protein. The type of RNA that participates in both steps is called messenger RNA. Process of transcription and translation are discussed further below. And the judge then goes on in 179 to refer to the most abundant forms of non-coding RNA being ribosomal. He refers to transfer RNA and its function. And then there's a brief account of microRNAs and small interfering RNAs. And over the page, 182, this is an account. Sorry, if I said the judge said this, I didn't mean it. I mean the agreed common general knowledge was this. There's a further account of small interfering RNAs, and if your lordships just see the last sentence of 182, such small interfering RNAs can be introduced into cells as double-stranded RNAs or as single-stranded RNA that folds in a hairpin structure, shRNA, which are then processed to active small interfering RNAs within the cell. And just pausing there, my lords, the reason why I'm showing you this is because, as we shall see, UPenn refers to all of these types of RNA as representing a different embodiments of its invention. Not just messenger RNA, but all of them. Transcription is then dealt with at 183, but translation is then dealt with at paragraph 192. And could I ask you, Lordships, just to read to yourselves 192 to 193?
Yes, thank you.
So transcription is the process by which DNA is converted into RNA. Translation is the process by which messenger RNA is converted into a protein. Messenger RNA being the only type of RNA that is involved in both of those processes. Can we then turn back to the judgment, the introductory remarks, paragraph 307. We looked at 312 with the judge reminding himself of the target for anticipation. Paragraph 307, so just looking at 4 or 5 above that, the judge says that Pfizer BioNTech's case on anticipation was set out in an extremely useful chart with its closing submissions. There were 3 routes, as I'll describe further below. My Lord, I do want to look at that chart. I know you've looked at it very briefly. I'd like to look at that chart again, and the reason for that is it provides a very convenient route map for the judge's findings, specifically in relation to route 3. So it's in the supplementary bundle. It's behind tab 27. And apologies that it is in landscape mode. Portrait. And if your Lordships have that, route 3 is obviously the one on the right-hand side. And the bullet points that appear, first of all, there's a reference to Claim 1, referring to a messenger RNA comprising a pseudouridine. Paragraph 4, in the same terms. Third bullet point, paragraph 56 discloses that pseudouridine refers in another embodiment to M1 psi in a list of 5 molecules. Just highlight that notionally, my lords, please. The reader would understand this to mean that M1 psi is a pseudouridine residue within the scope of Claim 1, paragraph 4, and that UPenn was presenting a preferred list of psi-like modified nucleosides, which included M1 psi. So 2 propositions in that third bullet point. A list of 5, and a preferred list of psi-like modified nucleosides. And then the fourth bullet point identifies the 3 pointers which my learned friend's case relied upon for the proposition that 100% of the residues of a given nucleotide would be preferred. Example 2, which is the methodology which is common ground, results in 100% replacement. Example 7 further teaches the greater the degree of modification, the greater the immunosuppression, which is another reason to make 100% modified nucleotides, and then a reference to the common general knowledge. And if you then, Lordships, please just turn, you can skip over the Claim 5 references, but the comments at the end, the last box, this is the case that was being advanced before the learned judge. Pursuant to Pfizer BioNTech's position on the law as set out in his written submission, selections from lists can be permissible when there are pointers towards the selection in issue. Selection of the claimed messenger RNA is a permissible selection in light of the specific pointers from the teaching of UPenn as a whole and the skilled person's common general knowledge. As such, UPenn contains clear instructions to make something that would infringe those claims, clear and unmistakable directions to do what the patentee claims, and is thus novelty destroying. That language, as we saw, comes straight from General Tyre. So that's a convenient summary of the case that was put before the judge. If we then turn to the judge's assessment of that route, which begins at paragraph 330, the judge identifies the nature of the case, the particular ingredients of Route 3 in paragraph 330. In 331, he identifies the reliance on paragraph 56 as defining what is meant by a pseudo-uridine, whether for the purposes of Claim 1 or paragraph 4. The judge then rightly identifies in 331 what is meant by, what is meant by pseudo-uridine in that context, which is pseudo-uridine itself plus the 4 other named possibilities. When the judge is referring to the other 4 named possibilities, he's referring to the pseudo-uridine derivatives. And then, as the judge says, plus any other pseudo-uridine known in the art. So the judge has plainly, fully on board with what the arguments are. He then says in 334 that although it was positioned as Pfizer's secondary case, he found Route 3 simpler, rather more persuasive, but I nonetheless reject it. And his reasons for rejecting that route are then set out in 335 to 339. And just pausing there, my lord, my submission is that the judge analysed Route 3 rightly in terms of a selection from 2 independent lists. First list being the list of different messenger RNAs in Claim 1 or paragraph 4, when read together with paragraph 56. And the second list being the list of percentage replacements in paragraph 74. And in the course...
So you said the list of different messenger RNAs. I don't think you meant that.
I think I did, my lord. The claim 1 is to a messenger RNA comprising a pseudo-uridine.
So what are the different...
So it would be a messenger RNA comprising pseudo-uridine psi, a messenger RNA comprising M5D.
Oh, I see. I thought you were making a separate point. It's when read together with 56. Okay, now I understand. Thank you.
I'm grateful. My lords, in the course of that analysis, the judge was rightly alert to the existence of pointers. Pointers to, or a pointer to, mRNA comprising M1 psi from the first list, and 100% replacement from the second list. And in addition, the existence of a pointer to the combination of messenger RNA comprising M1 psi together with 100% replacement. Now, if we look at his findings in 335, or the beginning of his findings, he accepts that Claim 1 or Paragraph 4 is a legitimate starting point, but he says, but both routes lead to Paragraph 56. Paragraph 56 is an odd creature because it is a definition section and not an expression of any technical preference for the listed nucleosides. And you recall that one of my learned friend's submissions, we just saw it in the novelty chart, was that Route 3 presents in paragraph 56 a preferred list of psi-like modifications. The judge disagrees. He is, in this first sentence of paragraph 335, dealing with part of the case that was put before him. And he says it's an odd creature. My lord, it is, in my respectful submission, the judge is saying it's an odd creature in the context of an allegation of anticipation. It's definitional.
Well, you say it's definitional, but is it? Because it's a statement of an embodiment of the invention. It's not in a definition section of the prior art. It's in a section setting out seriatim embodiments of the invention.
Indeed, it's in a section of the UPenn, a very lengthy section, setting out countless different embodiments of the invention.
Yeah.
It happens to be one of a number of definitional sections in the document. And that's...
May depend on what you mean by a definitional section.
Well, Lord, can I just continue the submission into why the judge is referring to it as an odd creature? This is a judge who's very familiar with patent specifications. He knows that patent specifications frequently include defined terms. He's not saying it's odd that EP949 includes a definition of the term pseudo-uridine. He's saying it's an odd creature in the context of an allegation of anticipation because, as a definitional statement, it merely defines what a term means rather than containing any technical teaching. And one can see that from what he says. In 335, he says, I've considered this in relation to obviousness too. So if your lordships turn to page 127, at paragraph 379, 379, little Roman 1, paragraph 56 does not naturally read as a technical teaching that the listed nucleosides are preferred or particularly beneficial. It is a definition, not a scientific statement. And that is an odd paragraph to rely upon for the purpose of an anticipation attack, when paragraph 56 contains no technical teaching. We'll look in due course, because that's not quite right. Paragraph 56 does contain some technical teaching. It contains some technical teaching which is to be found in the rest of the document in relation to one of the nucleosides to which it refers, namely pseudo-uridine. But it contains no technical teaching in relation to the other members of that list. So paragraph 335 starts with the judge addressing and disagreeing with one of the submissions that was made to him about paragraph 56. And he goes on to consider the second submission that was in that third bullet point, which is that paragraph 56 identifies 5 nucleosides. And he disposes of that in the second part of 335, where he says it's also open-ended because of the reference to any other pseudo-uridine known in the art. And my learned friend says, well, I don't know why he was doing that and it's all irrelevant, but he was doing it because it was one of the submissions that was made to him. And the judge considered it to be relevant for the reasons that one can see in page 127 again, paragraph 379, this time little Roman 3. he says paragraph 56, it's not a concrete list of 5 possibilities, because it also extends to any other pseudo-uridine known in the art. What the judge is pointing out there is the quality of the disclosure in paragraph 56. Quality, all part of the context, and in particular the context as to whether there is a technical teaching that is to be found in paragraph 56. And the judge is simply saying, well, it's actually open-ended. It's actually therefore not a concrete list, but a, well, I can't put it any other way, it's an open-ended list. So far in 335, the judge has made those 2 findings. And in paragraph 336, he says, in any event, M1 psi is not said to be preferred. Why did the judge make that finding? Well, the judge explained in paragraph 139, that was the first principle that we looked at in his summary of those 3 propositions in relation to pointers, that a particularly common form of pointer is a statement of preference. The judge is simply saying, as far as this list is concerned, one side of the ledger, which is the mRNAs with various different nucleosides, there's no special attention that singles out M1 psi. Now, let's pause there. What are the other nucleosides, as I say, in that list of mRNAs comprising a pseudo-uridine? The first of those is pseudo-uridine itself. What does UPenn itself actually say about the nucleosides that are in paragraph 56? Well, the answer is it says a tremendous amount about pseudo-uridine. It is common ground, and it was common ground before the trial judge, that the experimental data on pseudo-uridine are very promising. Indeed, pseudo-uridine was the best performing nucleoside of those tested. If your lordships please turn to the judgment at paragraph 303. This is the judge returning to the experimental work. He says there are 6 modified nucleosides for which experimental data are given: M5C, M5U, M6A, S2U, psi, pseudo-uridine, and UM. These vary in structure quite widely. There are in vitro experiments, experiments in cultured cells, and in vivo experiments. The only modification taken into the in vivo experiments is psi. And then he says in 304, the key message of UPenn about the experiments. The key message is contained in paragraphs 241 and 244 to 246. And he then recites those. First of those, thus pseudo-uridine modification increases RNA translation efficiency in vitro, in cultured cells, and in vivo, in multiple animal models and by multiple routes of administration, showing its widespread application as a means of increasing the efficiency of RNA translation. These findings confirm the results of example 12, demonstrating that psi mRNA is more stable than unmodified RNA. Further, immunogenicity of psi mRNA was less than unmodified RNA, as described here in above, figure 7 and figure 12C, right panel. And then over the page, paragraph 246, to summarise examples 13 to 14, the three advantages of psi messenger RNA compared with conventional messenger RNA: enhanced translation, increased stability, and reduced immunogenicity, observed in vitro, are also observed in vivo. Pseudouridine stands head and shoulders above the other 5 modifications which UPenn actually tested. What then about the other nucleosides that are within the scope of Claim 1 by virtue of paragraph 56? The other nucleosides being the 4 pseudouridine derivatives, M5D, and any other pseudouridine known in the art. What does UPenn say about them? What does it disclose as a matter of technical information, as a matter of technical disclosure? The answer is precisely nothing. There are no experimental data. They are simply described as separate embodiments of the invention in precisely the same language as the much longer list of untested modified nucleosides. And, my lords, it's not just the absence of any technical information. Let's think about the common general knowledge and the judge's findings, first of all in paragraph 306. Sorry, that's a very bad reference. Apologies. I think it must be 406. Sorry, my lords, I've got a bad reference. Oh yes, it's not 400, it's paragraph 382. Further and closely related point, which I think is important and powerfully in Moderna's favour, is that UPenn does not say why pseudouridine had worked so well, nor did Pfizer BioNTech have any real case that it was possible to work out why. There's then a reference to CRECO 2008, which isn't relevant for current purposes.
Sorry, what's the relevance of this? Because you introduced this point by saying, bear in mind the common general knowledge, and this is part of a key part of the analysis on obviousness.
Well, I'm sorry. You're quite right. It is part of the analysis of obviousness, but it's also important and relevant for the purposes of what does UPenn disclose or not disclose about the technical characteristics of the other modified nucleosides, which are within paragraph 56. I mean, the short point is, although this is part of the judge's obviousness analysis, the skilled person is presented with a list of compounds, 4 of which happen to be pseudouridines, 1 which doesn't, and has no way, because UPenn certainly doesn't explain, has no way of working out whether they are going to be of any utility at all. Because the judge says the skilled person's reading of paragraph 56 and paragraph 291 will be informed by this. So to this extent, the choice of other modified nucleosides to try would be made blind, and there could not be any inference that the choice in paragraph 56 was made on a concrete basis of understanding the mechanisms at work.
Yeah, but again, that's all about obviousness, and it's your own case that obviousness is not the test.
With my respectful submission, this is part of the judge's account of obviousness. This comes in the section of obviousness, but the judge is making findings in relation to obviousness which also bear upon the technical disclosure of paragraph 56. Well, I won't push that any further, my lords. The overarching submission is that the question of disclosure, the question of individualized disclosure, isn't just a numbers game. Context is relevant, and what's acutely relevant in this case is that we have a list, as it happens, an open-ended list, in respect of which there is one absolute standout performer, which is pseudouridine, and 4 pseudouridine derivatives, M5D, which is not a pseudouridine derivative, and any other pseudouridine derivatives known in the art, as to which there is no technical teaching. So when my learned friend says, well, you can just ignore all the other pseudouridines known in the art, he says that's just irrelevant. It isn't relevant because it informs the quality of the disclosure. But even if you were to write them out, and pausing there, I don't accept that there is any principled basis upon which they could be written out, for the reasons given by the judge in 335. The fact that there are, as it happens, no other naturally occurring pseudouridines is not part of the disclosure of UPenn. That is information which...
But it will be common general knowledge.
Sorry?
It's common general knowledge, if in effect, isn't it?
No, it's not. It absolutely is not common general knowledge, my lord. Can I remind you of your judgment in KCI, which was upheld by the Court of Appeal?
Right.
Bundle 3, JA3. Sorry, not JA3, it must be JA2. It is Garmin, tab 13. This is obviously, Garmin is not your judgment, but Mr Justice Henry Carr quoted the relevant passages from your judgment in KCI. So J2, tab 13, paragraph 89. The relevant legal principles were set out by Arnold J. in KCI, paragraphs 105 to 115, which passage was approved by the Court of Appeal. For the purpose of the judgment, certain principles are important to emphasise. I can probably take it straight to paragraph 95. This is Mr Justice Henry Carr. He says there's also a distinction between common general knowledge and information which it's obvious to acquire, and then quotes from Lord Justice Jacob having approved Mr Justice Kitchen, as he then was, in generics. And then paragraph 96. And this is the passage that I was alerting your Lordship to. The distinction between information that it might be obvious to acquire and the common general knowledge. What was the common general knowledge in this case? Common general knowledge was the existence of the RNA modification database. Paragraph 200 of the judgment.
So your point is the existence of the database was common general knowledge, but not all of its contents.
And that's what the judge found. Or rather, that is what is in the agreed common general knowledge. Paragraph 200, first of all. Paragraph 200. The skilled person would know of databases containing modified nucleotides, such as the RNA modification database. Paragraph 203, in 2010, it was possible to obtain a limited number of modified nucleotides, both naturally occurring and artificial. So the common general knowledge acknowledges the existence of both. And then paragraph 250, Moderna conceded point little 3, following the oral evidence. In my view, they were right to do so. This means that a skilled person would know that the RNA modification database existed, its purpose, the nature of its contents, and that it was searchable. They would not know its contents by heart, but would know how to access it, emphasis, when they needed to. Now, there was no evidence, there was no suggestion by either of the experts, there was no submission made by my learned friends, that in order to understand the disclosure of paragraph 56, it would be necessary, the skilled person would need to consult the RNA modification database. Had that evidence been given and had that evidence been accepted, then I would be accepting that information gleaned from that RNA modification database would be part of the common general knowledge. But it was never suggested that one needed to. The evidence was, and the case was, that it would be obvious to turn to the RNA modification database.
Yeah, and that's no good for anticipation.
And that's no good for anticipation. My lords, can we go back to the judgment? Which I've now lost, I'm sorry. Oh, here it is, I'm sorry. We were looking at the judge's analysis of Route 3, and we got to paragraph 336. And so far, up to paragraph 36, the judge has been considering the one list, the RNAs plus combining different pseudouridines. He then turns to the second list, which is the list of percentages incorporation. And could I just alert your lordships to what the judge says at the beginning of 337? As to pointers, we saw in the judge's account of the law his explanation that pointers need to be found in the document, in this case UPenn, not just plugged in from the common general knowledge. They're a facet of the gold standard, not a replacement of it. Not a license for holding something to be disclosed merely because it was an obvious choice. And if you turn, please, to just the preceding page of the judgment, paragraph 328. This comes towards the end of the judge's analysis of routes 1 and 2. The judge reminds himself in 328, it should be recalled that pointers are things which flag up something that sets aside the relevant element from the list, from the others, and that the standard is clear and unmistakable disclosure. So when the judge makes the findings that he does in 337, he's making those findings in the context of those statements of law. Now, I'm going to address you on the specific findings that he makes in 337, but just pausing there, 337 he makes findings, and 338 is his conclusion. He says that I therefore think that these pointers are not strong, not explicitly disclosed, but require analysis, and are not directly linked to the list at paragraph 74. Well, as we say, the judge evaluated each of those pointers, identified by my learned friends, evaluated them and the evidence upon which they relied, and he came to an overall conclusion which was plainly available to him.
But is that the right test? This is a question of novelty. It's a question of what is the disclosure of the document. And yes, of course, we proceed on the basis of the learned judge's findings as to the technical considerations that would bear upon the analysis, and most obviously his finding is to the common general knowledge, but after that it's a question of law, isn't it?
It's a question of disclosure.
Yeah.
It is, absolutely.
Yeah.
But it's not a...
It's not like obviousness, where it's a question of multifactorial evaluation for the judge.
My Lord, I think I wouldn't accept it in quite such stark terms. I would submit that the evaluation of the disclosure isn't just absolutely hard and fast rules. It's not just black and white language. It is ultimately, or the judge is entitled to approach it on the basis of an evaluation when he's looking at what is the strength of the pointers that are relied upon.
But I don't understand that, because it's either novel or it's not novel.
Yes.
The whole point about multifactorial evaluations is that two tribunals can reach diametrically opposite conclusions without either being in error.
Indeed.
You can't do that with novelty, can you? It's either new or it's not new.
Fair enough. Fair enough. It's either new or it's not new. Your Lordship may not accept the submission that the judge is looking at these pointers holistically, that he's looking at these pointers in the context of the document as a whole.
Yeah, well, your case is he was right.
It's another way of putting it. He's right, Lord. And so I'll come back to the particular criticism 337, but let's just look at the judge's follow-on conclusion. Because in 339, he says, well, okay, what if I'm wrong about that? What if I'm wrong and that there is in fact a pointer in favour of 100% replacement? He then says he would have rejected claim 3 even in those circumstances. For those two reasons: the absence of any pointer to the combination of M1 psi and 100% replacement, together with the fact that the case required combining something preferred, 100% replacement on this assumption, with something in an unclear and apparently open-ended list, M1 psi, he rejected on that basis. And the judge is there doing exactly what he has advertised in paragraph 139, when we looked at the 3 principles that he extracted from the EPO law as regards pointers. In general, what the EPO looks for is a pointer to the combination, and in a number of cases, there is added matter in combining a preferred member from one list with a member of another list for which no preference is expressed. Lord, so far I've looked at the law, I've looked at the judge's approach. Can I now turn to what's left of the appeal in relation to Route 3? Lord, I wonder if it might be a convenient time to pause there. I know it's 2 minutes before 15:15.
Well, it depends how much time you need in the morning, I would guess.
Quite, it does. I mean, how are you doing time-wise generally?
I'm doing very well, my Lord. There's no question that let me take my last 2 minutes. Why not? My Lord, if we take the grounds of appeal, and we look first of all, so this is core bundle tab.
Always an excellent thing to do on an appeal.
Always useful. So core tab 2, page 30. Ground 4, this is the judge is said to have erred in his construction of paragraph 56. judge failed to appreciate that paragraph 56 would be interpreted as more than merely definitional, and when read together with paragraph 4 and claim 1, provided the skilled reader with a clear disclosure of the psi-like modified nucleotides of particular interest. I think your lordships have received my submissions on that. We then turn to ground 5, whether or not paragraph 56 itself is definitional. When combined with paragraph 4 or claim 1 of UPenn, it discloses the use of M1 psi in mRNA and contains sufficient pointers to 100% replacement, which is in any event not a choice which is independent of the selection of nucleosides. Now, you can put a line, having heard my learned friend this morning, put a line through which is in any event not a choice which is independent of the selection of nucleoside. That has formed no part of his oral submissions and I assume is not pursued. So what's left in paragraph 5 is whether or not paragraph 57 is definitional. When combined, it discloses. And my lord, I think your lordship will appreciate what my submissions are in response to that now. I accept plainly that claim 1, when read together with paragraph 56, includes within its scope mRNA comprising pseudouridine, together with mRNAs comprising each of the other nucleosides, the 4 pseudouridine modifications, derivatives, M5D, and any other pseudouridine known in the art. So it's within that list. One could write out the constituent members of claim 1 read together with paragraph 56, and you would have a list. But the context of that disclosure is, as I have sought to emphasise, one in which there is an absolute standout technical teaching in relation to pseudouridine and a complete absence of any technical teaching in relation to any of the other nucleosides, and that includes M1 psi. So can I then turn to sufficient pointers to 100% replacement? And can we look first of all, my lords, at the three particular paragraphs that my learned friend relied upon this morning for the purposes of the general teaching. So they were paragraph 143, which is on page 122 of UPenn. Bear in mind, my lords, that this is one of countless paragraphs in this section of UPenn, which is just describing different embodiments. In another embodiment, a method of the present invention comprises increasing the number, percentage, or frequency of modified nucleosides in the RNA molecule. Pausing there, RNA molecule is not a particular RNA molecule, but any type of RNA molecule. And let me just make that good by taking your lordships back to paragraph 76 of UPenn. So this is bundle reference 102. This is another definitional paragraph that UPenn contains. In another embodiment, the terms ribonucleotide, oligoribonucleotide, and polyribonucleotide refers to a string of at least 2 base sugar phosphate combinations. The term includes in another embodiment compounds comprising nucleotides in which the sugar moiety is ribose. In another embodiment, the term includes both RNA and RNA derivatives in which the backbone is modified. Nucleotides refers in another embodiment to the monomeric units of nucleic acid polymers. RNA may be, in another embodiment, in the form of transfer RNA, small nuclear RNA, ribosomal RNA, messenger RNA, antisense RNA, small inhibitory RNA, microRNA, and ribozymes. The use of small interfering and micro has been described. In addition, these forms of RNA may be single, double, triple, or quadruple stranded. Paragraph then goes on to talk about different backbone modifications. Last sentence of this paragraph, each nucleic acid derivative represents a separate embodiment of the present invention. There's then in the next paragraph a definition of the term oligoribonucleotide, and paragraph 78, definition of polyribonucleotide. So back to paragraph 143. This is a disclosure of an embodiment not referable to any particular RNA molecule, to increasing the number, percentage, or frequency to decrease immunogenicity or increase efficiency of translation. Or, not both, or. And of course, as far as mRNA is concerned, one needs both.
So which paragraph are you on?
143 of UPenn. Next one was paragraph 186. And that was the one your lordships will recall. Page 131 of UPenn. These findings demonstrate that the immunogenicity of RNA is affected by the extent of nucleoside modification, with a greater degree of modification tending to decrease immunogenicity. And the last I wanted to refer to is page 140. This comes at the end of example 7. Paragraph 200. In summary, each of the modifications tested suppressed RNA mediated immune stimulation, even when present as a small fraction of the residues. So here's an express teaching that there is a reduction in immunogenicity even when present as a small fraction of the residues. And then the second conclusion, further suppression, was observed when the proportion of modified nucleosides was increased. Where is there an express disclosure in example 7 that 100% modification is the best for reducing immunogenicity? And the answer to that is the sentence in the middle of paragraph 213. Each modification, M6A, Psi, and M5C, inhibited TNF-alpha secretion proportionally to the fraction of modified bases. And that's absolutely fair. If one reads that, the skilled person seizes upon that rather than the particular conclusions which the authors have drawn from example 7, one could deduce that 100% would be better than 98%, would be better than 95%. It's why the judge, in my respectful submission, rightly says that these pointers, or this particular pointer as far as it relates to example 7, requires analysis.
I thought you referred to the heading of example 7 as having some relevance.
My lord, my learned friend relies upon the title of example 7 and
I understand, and
the passage in 213.
yes.
And my submission in relation to this is, yes, it's there, but this is not a conclusion that the authors spell out in 218. And indeed, if one looks at the purpose of this experiment in 212, the authors explained that most of the nucleoside modified RNAs utilised thus far contain one type, so that's 100%. And then the purpose of this experiment is to define the minimal frequency of particular modified nucleosides that is sufficient to reduce immunogenicity under the conditions utilised herein. In other words, the purpose of this experiment was to find the bare minimum. The conclusions that are drawn from this experiment in 218 are that each of the modifications tested suppressed RNA-mediated stimulation even when present as a small fraction of the residues. In other words, entirely consistent with the purpose for which this experiment was set up. And then there is a statement further suppression was observed when the proportion of modified nucleosides was increased. Lords, I will pause there.
Thank you. So we'll start at, start again at 10:30.